This is a guide to help navigate your court action. Please watch and listen carefully. A court action has a start, a middle, and an end. After papers are served, the first hearing is usually a child welfare hearing and/or a case management hearing. The case management hearing is the first hearing that the court begins to consider what the dispute is about. You require to attend the hearing either in person or via a WebEx video link. There is a pro forma list of questions that the court should ask. We will send you this form, and you must give us instructions. The court should then fix a full case management hearing between 16 to 24 weeks ahead to allow the preparation of the case to continue. We then usually have 16 to 24 weeks to further prepare your case. There are 3 essential rules, and you must understand these. Remember PPP, which stands for Pleadings, People, and Productions. Pleadings. There is a rule that your case must be set down in writing in advance. If you want to give evidence about something, it has to be written down. In other words, if it is not written down in advance, it is likely to be deemed inadmissible. This is called fair notice. People. We need the list of names and addresses of people who might become witnesses in the court action. You can have as many witnesses as you wish, but the court won't thank you for duplication of the same evidence. Think about this. And finally, productions. Documents, text messages, videos, reports. Anything that supports your case. We need productions as soon as possible. There are rules and deadlines which apply to the lodging of everything at court. You need to cooperate and help us lodge these things as early as possible to avoid difficulty. The middle, the full case management hearing. By this stage, PPP should have happened. Your pleadings should be complete or nearly complete. Your witness list with people should be lodged, and the production should be itemized and lodged with the court. At this hearing, the judge will go into detail about the case and want a detailed discussion about the issues in dispute. You require to be present in person or by WebEx video link. The court should fix a diet of proof. The end. The proof. If the dispute has not settled, the case will proceed to proof. The judge, known as a sheriff, will hear evidence from witnesses, both verbally, called parole evidence, and/or in written form, called affidavit evidence. Each witness will give evidence in chief and then be cross-examined, and then a final process called re-examination occurs. The judge will hear all the evidence and then give an oral decision about the case, or retire to consider a verdict and write a judgment, known as an opinion. Remember these essential rules. 1. Make regular appointments. Don't call the office on an ad hoc basis expecting a solicitor to be sitting waiting on your call. They are usually at court or engaged in previously arranged appointments. If urgent, leave a message explaining the urgency. 2. Emails are not instructions. Instructions are only given verbally to solicitors because we don't know who sends emails. Thank you for watching.